You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have a BVR, another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're going to reach out to Melanie. My assumption is there's a BDR call for that too. So I don't know what her comment looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yeah,
want to
sure.
talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds, and then we're almost
No
done.
problem, Judge.
Good morning, Mr. Randolph. Good morning. So you're charged with assault, causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent.
In this clip, the judge confronts a defendant who is already out on bond for a murder case, yet has now picked up a brand new assault charge. Officers responded to a disturbance involving an elderly patient in a medical facility. Staff told police the defendant refused to leave even after being told multiple times. The witness, part of the nursing staff, stated the defendant was trying to pressure her grandfather, who has dementia, into signing over power of attorney. When staff blocked the attempt, the defendant allegedly became physical, pushing the nurse by the face. The nurse stated she felt pain, which meets the requirement for assault. After confirming probable cause, the judge turns to the defendant's bond violations, demanding to know why she still doesn't have her GPS monitor. Conflicting curfew orders appear to exist, one requiring her home at 7 p.m., another at midnight, but the judge emphasizes she should still follow orders and raise issues in court rather than ignore them. Her lawyer begs for leniency, but the judge is firm. She's on bond for 2 serious cases, and the city must be protected. The judge refuses to release her for the monitor and warns her consequences are coming.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched from an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of any weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I was out
Don't.
I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never a danger. Just I don't intend to be in danger either.
All I want my streets safe.
They
And
was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Can you
understand?
protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
Go. Exercise.
And I'm
the right
running from these
to stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want,
I just want to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I don't know these people.
Listen, just I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on.
In this extended hearing, the defense argues the defendant's curfew violations were caused by conflicting bond conditions. The magistrate issued a 7 p.m. to 7 a.m. curfew, while the felony bond listed midnight to 6 a.m. The judge listens but stresses that even with mixed instructions, the defendant was still required to follow something, not simply leave the house without approval. GPS data showed she made unapproved exits on May 1st, including one at 7:52 p.m. and another after 8:50 p.m. Her attorney pleads for the judge to simply admonish her rather than revoke her bond entirely, explaining she was newly released and the confusion was genuine. But the judge reminds everyone she is out on bond for a murder charge, has now been charged with a new assault, and is already violating the conditions meant to protect the community. The judge refuses to rule immediately, saying she will stew on it, leaving the defendant's future hanging in suspense as the courtroom grows tense.
You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. A law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any food and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything unquestioned about his whereabouts," and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one leg stand. Due to the defendant, 0 out of 4 on the one leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty twisted tea of alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
I don't mind running it, please.
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Warwares 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to biweekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol in the, no, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay. Those are you. Sorry, Maria. All right. We're going to keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001. We'll just raise it up to 1,001.
6,000.
It's 5,000 now,
Right.
so I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out.
Yes, Judge.
All right, good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay. Any practicabilities?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is other.
Great. Okay, come on. Mr. Bustamante, I know that there are two sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number one, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at two more very serious violation of a protective order case. That in and of itself is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir, Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever it may be.
This clip follows a defendant accused of randomly harassing two women on the street. Witnesses told officers the man followed the women, verbally harassed them, and became increasingly aggressive. When they attempted to walk away, he allegedly chased them. A bystander intervened, placing himself between the women and the defendant. At that moment, the defendant reportedly struck him with a closed fist. The victim experienced pain, and security detained the defendant until officers arrived. In court, the judge lays out strict bond conditions: no alcohol, no drugs, no weapons, no contact with the victims, and stay away from the area of the incident. The defendant repeatedly insists he was not a danger and claims he didn't know the people involved. But the judge warns him to stop talking before he accidentally incriminates himself. The defendant emotionally describes being afraid for his life and having recently attended his mother's funeral, but the judge cuts him off, explaining that bond rules are not optional and he must comply if he wants to remain free. The clip ends with the judge ordering him to sign new conditions and wait for his court-appointed lawyer.
Smoke signals. No means no.
It's a problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these two.
I understand, Your Honor.
This order only applies to these two. Don't use the other kids to try to have contact with these. If you do,
We all live together. Right.
Now you don't.
Right, I go to mom's house.
Best go somewhere else because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't.
Understand?
Don't go into
You
the
have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket.
That's the problem. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question? Ask me.
Ask the lawyer.
Okay, so, okay.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank
Okay,
you.
so we need him to sign conditions
Yes,
with
sir.
Roxanne whenever she's ready.
You come up here so I can.
I'm not equivalent. I want to go.
Sir, please.
I don't want to go to jail.
Good morning, Mr. Godine.
You don't, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing in what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Godin, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find that becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible.
Okay.
And not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that tolerance and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes,
I
sir.
don't want you to kill yourself. Life is way too short. You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand? Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Come
Your
on.
Honor.
Thank you, Ms. Barks. So it looks like you are wanted out of the state of Louisiana for a larceny. It's a misdemeanor. Am I right?
Yes, Your Honor.
Okay. Your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number one, are you going to go back to Louisiana if we give you a bond? Number two, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger. If you're danger, you know,
I will,
well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are.
Your Honor, the demanding jurisdiction requested no bond because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTA was issued out from Caddo Parish on July 21st, 2022, but then she picked up this larceny within the last couple of months this year. While that was an FTA, state requests that there's sufficient bail be set for the fugitive to be returned to the demanding jurisdiction. State requests a $10,000 bond because of the fact that it's a 3-year-old FTA. On top,
This case is 3 years old.
no. The other
The DWI.
pending, right? She also is wanted for a DWI out of the same parish, but this specific fugitive case is for the larceny. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years
See
old.
what I mean? That's what I'm saying. You know, yeah, I know what you're going to tell me, but paper tells me another thing. And that's a big problem. That DWI has been open for 3 years. Now, the only reason we have you is so are you okay with the bond though?
Okay, with a bond, just a sufficient bond that she return herself, Your Honor.
Okay.
yes, Your Honor.
Judge, we wouldn't be opposed to 10,000 if you could set it at that.
Okay. I want you to understand that I don't play games.
Yes, sir.
I'm not going to do this repeatedly.
Yes, sir.
I can set you a bond now,
Yes, sir.
but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. Not, I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No,
Just go turn us.
go turn yourself in. The other thing I'm going to tell you is that Murphy's Law, you know, what can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble, abducted by aliens. Don't matter.
Yes, sir.
As soon as you get out, I would go because that's a lot of money that someone else is ponying up for you to get out. Do you understand? All right.
So I just wanted to highlight, and obviously the court set the bond, I'm not disputing that, but just because there have been 2 other fugitives from Caddo Parish that have waived, and I have 6 total from Louisiana. I imagine the transport is going to be soon. So regarding financial capabilities on restoring the bond when returned to Louisiana.
So let them know, you know, what he's trying to tell you basically is that because Louisiana, we have so many people in our jails from Louisiana, we have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple of days, they'll probably have you back in Louisiana as opposed to someone dropping 10,000. You said 10,000?
Yes.
As opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is, and then you guys can decide what you want to do. Has she waived already?
She's waived. That's why I can stand down if you want to talk to her.
Once, because you have already waived, so we give them a certain amount of time to come pick you up. They don't.
In this surprising case, officers describe seeing a driver run a red light, make an illegal U-turn, and nearly collide with another car. When they activated lights to stop him, he continued driving past multiple empty parking lots before finally pulling into one, while calmly eating fried chicken the entire time. When the officer approached, the defendant refused to open the window at first and repeatedly claimed, "I don't have anything." He did not have a driver's license on him and was reportedly incoherent when asked for his name and date of birth. Once identified through dispatch, officers conducted sobriety tests. He showed 2 clues in the horizontal gaze test, 5 out of 8 on the walk and turn, and could not properly complete the one-leg stand. Inside the vehicle, police found cold, unopened packs of alcoholic drinks, plus empty containers including a large beer can and a bottle of liquor. He refused both breath and blood tests. The judge finds probable cause and orders him to stay away from alcohol, drugs, and any new legal trouble, stressing that bond conditions must be followed strictly.
Come get you within that time, we release you. Once, if you want to post bond, you have to withdraw that waiver and you lose all the time that you've accrued toward that. I'll let it explain to you, and you guys tell me which one it is.
Yes, Judge. All right. And Judge, I guess we need to have Bushnell and DeRoyan brought out as well for their pre-signed waivers.
Just enter in the pre-signed waivers, unless you don't want them to come out to enter, then
I don't care. Just have them sign it and get it. Yeah.
Well, they don't really need to sign, pre-signed.
And just explain to them if they
Yes,
have a
Judge.
problem, or if they don't believe you, or they're giving you a hard time, just let me know.
Okay, thank you, Judge.
Good morning, Mr. Garza. Good morning. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, an undercover law enforcement officer observed a vehicle conducting multiple donuts in a parking lot in close proximity to other vehicles and pedestrians. The law enforcement officer maintained visual of the vehicle until another law enforcement officer was able to conduct a traffic stop of the vehicle and detain the defendant. The defendant admitted he was the one driving the vehicle and doing donuts.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. Does he have a license?
It is eligible, Your Honor.
Okay, I'm ordering you now as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first I'm going to put you in jail. The next thing I will take your ability to drive away. Do you understand?
Yes, sir.
How old are you, sir?
17.
You want a court-appointed lawyer?
So what's up?
You need a lawyer to represent. Do you know if your family's going to hire you one, or do you want to apply? Okay, so you don't want to apply for a court-appointed lawyer. Okay. I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while I get your bond conditions. Don't drive maniacally. Do you understand? You are also not allowed to drive unless you have car insurance in your name as well. If I find that you're doing without it, it's not going to go well.
Yes, sir.
Come on. All right. Good morning, Mr. Ramirez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a major accident. The law enforcement officer observed a house with damage to the garage and the front of the house. Additionally, a Harris County Constable patrol vehicle was parked in front of another home and was damaged. The law enforcement officer observed the defendant's motor vehicle to have damage as well. The law enforcement officer observed the defendant to match the description given by dispatch and detained the defendant. The law enforcement officer met with a witness who recorded the accident and spotted the defendant as the driver. The law enforcement officer ID'd the defendant by his Texas driver's license. The law enforcement officer observed a strong odor of alcoholic beverage emitting from the defendant's breath, red bloodshot eyes, and slurred speech. The defendant declined to perform standard field sobriety tests. The DIC was read and the defendant agreed to provide a sample. However, due to the defendant's age, the law enforcement officer obtained a blood warrant, which was then executed.
Any prior DWIs?
No, Judge.
License?
License.
Okay, Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. I will revoke your bond, put you in jail. Do you understand?
Yes, sir.
If you become a danger to my city, I'm going to do everything in my power to protect it. You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
Yes, sir.
How old are you, sir?
18.
Do you have the ability to hire a lawyer?
Might, possibly, yes, sir. Not sure. I did just apply to appoint one.
Are you working? What do you do with yourself?
Yes, sir, I do work. I'm an employed full-time cashier at Bunsa within Katy, but the money.
Don't, I just want to know if you're working.
Oh, yes, sir.
All right, good job. So I'm going to appoint your lawyer today.
Thanks, sir.
Don't use. I don't care where you're going, what you're doing. I don't care if it's Jesus asked you to break bread. Don't use. It's not going to go well. Do you understand?
Yes, sir.
All right. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while we have you sign conditions and find your lawyer.
Okay, thanks, sir.
All right. Good morning, Miss Reed.
Good morning.
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 26, 2025, a law enforcement officer was dispatched to a Target store in reference to a shoplifter in Harris County, Texas. The law enforcement officer spoke with the complaining witness, the loss prevention officer, who stated that the defendant was observed on videotape obtaining items without payment. The defendant was observed on camera grabbing multiple items of merchandise, placing them in her backpack, and bypassing all points of sale without attempting to pay for the items. The complaining witness stopped the defendant after they had passed all points of sale, and the defendant was ID'd by name and date of birth. The total value of the items taken was $119.97.
The co-defendant?
Let me check.
Ms. Reed, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any Target for any reason. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. Likewise, don't pick up any new cases. Do you have the ability to hire a lawyer, ma'am? Okay, we can have you fill. Did she fill one out?
Yes, Jade Reed.
Okay, you're currently in school?
Yes, sir.
Are you in school full-time?
Yes.
Okay, I'm going to appoint your lawyer, ma'am. If you want to go to Victoria, we'll have you sign a reset. After that, we'll have you take you sit in the jury box while we find you a lawyer, and then we'll have you sign bond conditions as well, ma'am. Thanks. Good morning, Ms. Reyes. You were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 25th, 2025, a law enforcement officer was dispatched regarding a DWI investigation in Harris County, Texas. The law enforcement officer who conducted the traffic stop stated he observed the motor vehicle traveling the wrong way down Commerce Street. The law enforcement officer stated to the investigating officer that he observed red, glossy eyes. The other law enforcement officer arrived on scene and observed bloodshot, glossy eyes. The defendant admitted to drinking small margarita sample-sized drinks. The defendant stated she did not know she was traveling the wrong way down the street. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 3 out of 4 on the one-leg stand. The defendant consented to a roadside preliminary breath test yielding a 0.12. The DIC was read, and the defendant agreed to provide a breath sample for the breath test strip reading a 0.086 and a 0.088.
Okay. Ms. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, I will put you in jail. You understand, man? Any prior DWIs?
No prior DWIs.
License?
Eligible.
Okay. You are not allowed to drive unless you have a valid license and insurance in your name. You understand? That is also a condition of your bond. I will appoint your lawyer today. So what we'll have you do now is I'm going to have you head on over to Victoria, sign a reset. We'll have you take a seat in the jury box. I'm going to get your bond conditions. We'll have you sign it, and we'll have you speak to a lawyer here momentarily, ma'am. Okay? Please. You are Marcus Taylor. Mr. Taylor, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance/unknown weapon call. The law enforcement officer met with the complaining witness who stated he is an employee of the State Veterans Home on the nursing staff.
John Garza?
The complaining witness states that the defendant is unwelcome at the facility and has been asked to leave on multiple occasions, and the defendant has refused to do so. The complaining witness stated the defendant was attempting to have his grandfather sign power of attorney paperwork. However, nurses intervened due to the grandfather being diagnosed with dementia. The complaining witness states that the defendant used force to remove the complaining witness from the grandfather's room by pushing the complaining witness on the chest with his hands. The complaining witness stated he felt pain. The complaining witness positively ID'd the defendant. Law enforcement officers detained the defendant.
This final clip features a defendant already out on bond for a criminal mischief charge who has now picked up a DWI case. Officers say he drove recklessly through an intersection, nearly struck another vehicle, then hit a curb before finally stopping. During the stop, officers say he appeared confused, had difficulty understanding instructions, and struggled with field sobriety tests. Several alcohol containers, both unopened and empty, were found in the vehicle. The judge reviews the report and confirms probable cause. She then issues a stern warning. While out on bond, any new charge can put him right back in jail, and picking up a DWI is already a major violation. He is ordered not to drink, not to use drugs, not to drive impaired, and not to violate any bond conditions again. One more mistake, the judge warns, and his bond will be revoked immediately.
Defendant without incident.
Okay. Mr. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. You were also ordered as a condition not to be in possession of any weapons as well. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria's Center recess. After that, we'll have you take your seat in the jury box. While we get your bond conditions, we'll have you sign it. And after that, you'll be free to go.
This is affidavit, Judge.
This one, Judge, is page 2. Avila, Diaz.
And do another Spanish speaking on down too.
Judge, those bond conditions, do we want to do no returning to?
No. You don't need to do anything because I'm going to have her monitored like.
Yes, sir.
Yeah, we'll get to it in a second. Come up. You are Marvin Avila Diaz.
Yes, Marvin Avila Diaz. Yes, sir.
You are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed for you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. Officers met with the complaining witness who stated that the defendant and him are in a dating relationship. The complaining witness stated that they had just dropped friends off and started to argue about the vehicle they were driving. The argument became physical, and the defendant struck the complaining witness in the face with a closed fist multiple times, causing bleeding and pain. The officers observed the complaining witness to have dried blood on his face. Take a closer look here, Judge.
Mr. Avila Diaz, I'm going to find that there's sufficient probable cause to go forward with the case. Any with alcohol or anything a factor? I am ordering you now as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons. Mr. Avila, I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put a detainer on you and you will be stuck in custody until this case is over with, and then you get shipped to immigration. Do you understand? Yes, sir. Get no more warnings. Mr. Avila, I'm going to protect my city at all costs, and if that means putting you in jail, I will do it in a moment's notice.
Judge, the law enforcement officer observed the defendant to be in the vehicle, but to be in the front right passenger side.
Pero estaba en el lado del
It
pasajero.
does not indicate
Y
that
no
alcohol was a
indica
factor.
que había alcohol como un factor en esto. Nadie estaba
There is a protective order that has been issued in this case.
una orden de protección.
Get to know it. If you do something to violate this protective order, the state can and will probably file a violation of protective order against you. And that is one of the worst cases that you can make up.
Otro codazo feo que puedes agarrar. Entonces no hablas con él.
Are you working at this time?
¿Estás trabajando en este momento? No, sir.
Are you in school full
¿Estás
time?
estudiando?
Ya terminé.
I completed it.
It's time for you to do something. You need to either work full time or you need to be in school full time, but doing nothing, it's not going to work. That is also a condition of law. I will appoint you a lawyer today, but I'm going to bring you back in several weeks to see what you have done to get a full-time job. If it's nothing,
Voy a averiguar qué estás haciendo para conseguir.
do you understand?
¿Entendió? Contéstele al juez.
I'm going to have you sign a receipt with Victoria. After that, I'm going to have you take your seat in the jury box while we create your bond conditions.
Siempre vas a
Mr. Yepes Ovidio, you are charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 26,
El 26 de abril
2024,
2024,
a law enforcement
un
officer
oficial
was on
policial
patrol
estaba
in Harris County,
patrullando
Texas,
aquí en el condado de
when he
Harris,
observed
cuando
a
él
motor
observó
vehicle
un
going 82
observó
miles
un
per hour
vehículo
in a
que iba a
65
82
mile
millas
per
por
hour
hora
zone.
en una zona de
A
65
traffic stop was
millas.
conducted.
Pararon
The law enforcement officer
el
ran the
oficial
plates and came back
miró las
with no
placas
records.
y la placa vino sin
The
ningunos
defendant
récords.
stated he did not speak
Entonces el
English.
acusado dijo que no hablaba inglés.
The law enforcement
Y el
officer
oficial
discovered a
policial
case report was made
que
on
descubrieron
March
que había un
27,
reporte el 27 de
2025,
marzo de
with the same
2025
vehicle
con
in
el
question
mismo vehículo
displaying a paper
que
plate,
tenía una placa
but
de
with the
papel,
matching VIN number of the vehicle,
pero que correspondía al
with
al
no
número del
record shown on the
vehículo,
vehicle.
pero no tenía ningún récord tampoco.
A Spanish-speaking law
Un
enforcement
oficial
officer
que
was
hablaba
informed
español
by the defendant that the defendant purchased
le
the
dijo
car
al
3 days
acusado,
ago
el
on
acusado le
Facebook
dijo que lo compró
Marketplace
hace 3 días
and
en
was
Facebook
given
Marketplace
that paper
y
dealer temporary
le
tag.
dieron ese
The
placa de
defendant
papel.
was questioned
Y
about the
le
March
hicieron
27th incident,
una pregunta
to
sobre
which
el
the
27 de
defendant
marzo
admitted
y
he was
usted
in
admitió
possession
que
of the
estabas en
vehicle during that
posesión
incident as well.
del vehículo durante
The
ese tiempo
defendant
también.
then admitted
Y
to
después
operating a motor
admitiste que
vehicle
estabas
with a
manejando
fake
ese
temporary tag on the
vehículo
vehicle.
con una placa falsa.
The defendant further
Y
informed the
después
law
el
enforcement
acusado
officer
dijo
that
al
he
policía
purchased
que
the
él
plates
compró las
off
placas
Facebook
en
Marketplace
Facebook
and met up
y
with a guy
se
3 days
encontró con
prior
un
to the
tipo hace
incident
3
in
días
a Walmart parking lot
en un
to receive the fake
estacionamiento de
plates.
Walmart para
The
comprar las
defendant was
placas.
positively identified by his citizenship card from Peru and
Que tienes
Venezuela.
un carnet de Perú y de Venezuela.
License? Mr. Yepes Ovidio, I'm going to find that there's sufficient probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is a condition of your bond. If I find that you violate these conditions, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, immigration finds you because they sweep it hourly. They will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Para inmigración, ¿entendió? Conteste.
Judge, there's no driver's license information populating for the.
This is an affidavit. This is a promise you're going to make to me that you're not going to drive.
Estás diciendo que vas a
I don't care what your excuse is. I don't care what your justification is. If you drive, it's really not going to go well for you.
No te va a ir bien.
Do you understand?
¿Entendió? Sí, señor.
We're gonna have you come up here, swear to us that you're not gonna
Firmar
drive.
ese documento
After
jurando
that,
que
I'll
no
have you
vas a
take a seat in
firmar.
the jury box or
Y
with all
para
conditions
tomar un
ready.
asiento.
Have you sign it.
Para firmar los dos.
Yes, Your Honor. No, Your Honor. Speak up loud enough for me to hear
Good
you.
morning, Mr. Melcher. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a prior DWI and they roll up to your window and they smell alcohol or dope, it's probably not going to go well for you. What we're doing today, from now on, is a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Understand?
Yes, sir.
You're giving up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you.
Thank you, Judge. Maybe we need excuse.
Good morning.
So I'm here on Mitchell Estrada. Gary Tabachny said he spoke to you yesterday on the
Yeah.
phone.
Do you have the cause number?
No, cause number in Harris County.
No, but for the other case in
No,
court.
it's, they're temporary case numbers, some of this.
I know, but the cause number for the court 11 case, because that'll help us pull it up.
Spin.
But that'll work too. What is this?
I have to spend it 030-604-31.
Another defendant is brought up for a bond violation after failing to pick up the GPS monitor the judge ordered. When asked, he simply responds, "Oh, yeah," confirming he did not comply. The judge immediately revokes his bond, raising it from $5,000 to $6,000, explaining that he was given a clear order and ignored it. The judge tells him he will remain in custody and that if he bonds out, he must follow all conditions or risk further consequences.
I'm glad Gary spoke to you because he told me.
Blaze, I need your help real quick.
Absolutely, Your Honor.
Can I give you a call? Oh, she pled already?
Not that I'm aware of. On what case are you looking?
Is it Mitchell Estrada?
Yes.
Oh, I thought she had an open DWI. She only has these two out of county.
Two in Lee County, she has no cases here.
Okay. Can I give you a cause number?
Is this Michelle Estrada?
Mitchell, yeah.
Yes, I see that.
So she has two out of county cases from Lee County. They're asking for a bond to be set so that she can bond out and go back to Lee County. Because otherwise, essentially, whenever you get picked up in Harris County for a case that's out of county, Harris County holds you here for 10 days. And at that point, if the out of county doesn't come get you, I give them a PR bond.
Is there not a, so that's what I guess my confusion is.
She's been in custody. The hold was placed on the 29th. So she must have been arrested here this past Tuesday. And at that point, Harris County told Lee County, hey, we got your person. So Lee County puts the hold.
I'm trying to figure out, so we don't have any charges.
Correct.
You do not.
Yeah, it looks like she got taken out Class Ds. I mean, that's, however you do it, Judge. What do you mean?
She has a bail jumping, and I wanted to just run it by you guys and see. One is a bail jumping, and another one is a PCS 1 to 4.
Can I talk to Dave real quick? I think it's also legit.
Yeah.
I've not, probably in the entire time I've had this, we've only had this one other time where it's been an issue like this, where we've had someone come and ask for a bond on an out of county case. So I want to make sure that, I guess, everybody involved is.
Understand. It was really, I got a text this morning. Is anyone in state court? I said, yes, I am.
I mean, I'm not, do we have her?
No, because it's a temporary case number. It's not even a court filing.
The thing is that we're not going to get her here until the 10th day pops up. So she's basically just sitting in a holding cell in from 1200 Baker until, so what happens if we set you a bond now, you have to go let her know that the bond has been set. She has to make it as soon as she gets out. She has to go turn herself in Lee County. Because otherwise she's just not going to know. They want a bond set so she didn't sit there for the next 10 days or 8 days.
But Judge, the issue with this one, and this is largely outside of the DA's office role in the out of county. For this
No,
one.
but I wanted to still be,
I know, but the issue with this one is equivalent to whenever I request the interstate compact agreement to be entered, is we're largely divorced from that proceeding, and the hold is placed with the sheriff's office. So they communicate with the demanding jurisdiction. If anything's going to happen, it's going to be with their jurisdiction and our sheriff's office. So for the most part, there's no active matter in this court to be contested directly. And like, there's nothing that can be
set her a bond.
But there's no case to set a bond to. That's my point. Is right now there's nothing filed. There's no case number to enter in filings for. So it's like the interstate compact agreement. If somebody asks to
Do you
set a
hear
bond,
that? So there's no,
because sometimes they do create a case. That does happen. I've seen it before. You've seen it before.
basically what he's saying is until the 10th day, no case number is created for me to attach a bond to.
No cause number to attach.
Right. So there's nothing to be filed because there's nothing to be entered into. So it's filing documents for a case that doesn't exist. For the hold itself, there's numerous reasons the hold can be created without a case being created. And this is just one of those administrative mechanisms that happen between.
There has to be a way that we can give a bond or a PR bond or some way to release.
Right, but typically, and this is largely where I have to kind of take a step back, but if it's the demanding county that's wanting them, that's where the conversation should be, because they're the ones that want.
Have you reached out to Lee County yet? And I forgot to ask this Gary yesterday.
I was just told to come by about an hour ago.
Because it'd be the equivalent of if there's an out-of-state jurisdiction that withdraws their hold or their warrant, is I would ultimately
Is there a
dismiss
way
the
that I
case.
can put bond?
On a February case?
Do me this. Give me a second. Let me reach out to admin to see what more we can do.
Oh, in terms of if the clerk's office, if not, and that's again.
Yeah, can you give me, let me kind of thin it out a little bit, help the lawyers that are waiting, and then, because it's going to take more time for me to reach out to admin to see what I can do.
I'll hang out.
Yeah, just give me, and I'm sorry that you have to wait. Do you want to go, leave me your cell phone, and then I can text you, so you don't have to wait, and then you can always Zoom? So we don't have to just sit and wait?
Do that.
Yeah.
I was appointed on Marvin Avila this morning, Judge.
He's just here on bond.
He's on bond.
Oh.
So I understand that well, there was magistrate's conditions that were done onto it, but I understand that
All he did was no contact, no weapons, and he's not doing anything now. So hopefully we can either work full-time, get into school, or do something. So he's, doing something.
they did the RIP this morning. The person says that they just called the police to get things sorted out, but that they didn't want to press charges onto it. So the state had asked for no threatening, harassing it. That's what's already on there. And then
I ordered no contact, but have you guys reached out to the complaining witness in this case?
they did, the RIP's been done. And then the message between Sebastian and them.
Judge, the state's willing to agree to threatening or harassing and to remove a residency restriction.
Okay. Come up.
Le voy a estar traduciendo lo que diga el juez. Así que,
Two things.
dos cosas.
I want you to understand
Quiero que entienda usted.
that I've had to take in a bunch of people in jail today
Ha arrestado a varias personas en la fecha de hoy,
because they continue to violate conditions.
violando las condiciones de fianza.
I've already warned you
Ya te di la
about
amonestación
whether you
tocante
appear with permission and what the consequence
a las
is if you're not.
consecuencias si no sigue las reglas.
I will modify the
Se
conditions
lo voy a modificar
now
las reglas por ahora
threatening or
para que
harassing
no tenga
contact.
contacto amenazante.
You need to understand what is threatening or harassing. It
Yes.
doesn't matter what you
Caso.
think.
No es lo que usted piensa,
It is what they perceive.
es lo que ellos perciben ellos.
If I go like this, is
Yo
that
voy así.
threatening or harassing?
¿Es amenazante?
It is.
Sí es.
Find you in jail.
Y lo puede estar en la cárcel rápidamente.
Is there a protective order in this case? Yes, there is a protective order.
Hay una orden de alejamiento.
Right, so we'll modify that.
Va a ser modificada.
Mr. Avila,
Señora Ávila,
when people have too
cuando la
much
gente
time on
tenga
their
demasiado
hands,
tiempo en su tiempo,
they
en sus
become
manos,
self-destructive.
entonces empiezan a destruir ellos mismos. ¿Qué edad tiene usted?
21.
21.
You're 21 and
Tiene
you're doing
21 años. Y
absolutely
no está haciendo nada.
that's not going to work.
No es aceptable.
I want you to be a
Quiero que usted sea una persona productiva, sea trabajando o esté en la escuela.
and I'm going to bring you back with
Y
an
vamos a regresar
sure.
en las próximas semanas para verificar
Do
qué es
you
lo que está
understand?
pasando. ¿Entiende usted eso?
Hey. All right.
Está bien.
Steve.
No, todavía no, señor, porque va a firmar las condiciones. ¿Ok? Entonces tome asiento hasta que ellos pasen
Thanks,
sus
Juan.
nombres. Thank you.
We'll modify everything now.
Judge, you ready to go over a few?
Give me 1 second. Let me do I have
Oh, yeah,
a ton of bail orders. Good morning, Ms. Smith. Ma'am, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. Both of those are Class A misdemeanors. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. The officer interviewed the complaining witness on scene and found that the defendant observed the second complaining witness, another woman, and complaining witness 1, her boyfriend, open the apartment door. The defendant attacked complaining witness 1, leaving visible scratch marks on her chest, shoulder, and hand. The defendant then yelled at complaining witness 2, a stranger who tried to hide in a closet, when the defendant followed her and slammed the door on her toe, causing pain and her toenail to come off. The defendant then went downstairs and smashed complaining witness 1's front windshield.
So we have, I guess, the girlfriend and then just an unknown person.
Yes, Your Honor.
Okay. Ms. Smith, I'm going to find that there's sufficient probable cause to go forward with the cases. I'm now ordering you as a condition of your bond not to have any contact with either of the complaining witnesses and not to be in possession of any weapons. Do you understand?
Yes.
If I find that you violate these conditions, if I find that you pick up any new cases, I will revoke your bond, put you in jail. No more PR bonds. You understand?
Yes.
Let me see if there's a protective order that's been issued. There is a protective order that's been issued on the 27th of last month. I would get to know it. If you do something to violate the protective order, the state can and probably will file additional cases against you. Violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do. You've got a great lawyer here. Listen to him and he will take care of you. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. For now, we will have you go to Victoria, sign a reset. You will then take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you, Your
Thanks,
Honor.
guys. So can you file
Right this way.
no contact, no weapons on both of the cases, please? So you are Ms. Martinez. Ms. Martinez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
Thank you, Judge. On April 26, 2025, a law enforcement officer observed a motor vehicle fail to slow down as it crossed train tracks, causing all 4 tires to come off the ground and the vehicle to go airborne. The law enforcement officer observed the motor vehicle land, lose control, and nearly crash. A traffic stop was conducted. The law enforcement officer contacted the driver and the sole occupant of the motor vehicle, who he observed to have glossy eyes and a strong odor of alcoholic beverage emitting from her breath. The defendant stated she was just at a bar called the Sugar Room. The defendant stated she had 3 alcoholic beverages. The defendant stated she had chronic back pain but was willing to perform the standard field sobriety tests. A 6 out of 6 was recorded on the HGM, a 4 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The law enforcement officer observed a receipt in the defendant's purse showing she had purchased 8 alcoholic beverages throughout the night. The defendant refused breath. A blood warrant was signed and executed.
Okay. Any prior DWI? Okay.
So, Your Honor, there's no traffic offense stated. He claims that the car went airborne, all dukes of hazzard.
Sure.
Yet there's no evidence to support that. I mean, did all wheels come off?
This is
at
a
the same
probable
time?
cause hearing, right? We're not going to get evidence at this point, you know. I think that there's sufficient probable cause to go forward. Now, it doesn't mean you're guilty, but it's enough to go forward for now. Ms. Martinez, I am going to find that there's sufficient probable cause, and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, we will revoke your bond, put you in jail, no more PR. You understand?
Understand.
Because you have a lawyer, we will waive your appearance. You don't need to waste your time coming to court, but you must stay in touch with Mr. Butler, and he'll tell you when you have to come back to court. For now, we'll have you go to Victoria Center Reset. We'll have you take a seat in the jury box while you get to pretrial services, sign your documents, and then you.
All right, appreciate it.
Good morning, Mr. Marshall. Good morning.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 25th, 2025, in Harris County, Texas, a law enforcement officer conducted a traffic stop on a vehicle going 58 in a 40-mile-per-hour zone. The law enforcement officer made contact with the defendant driver and could see in plain view a pistol and a bag of marijuana next to the defendant. The law enforcement officer detained the defendant and found another bag of marijuana in the defendant's jacket pocket.
Okay. Mr. Marshall, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand? If I find that you do, if you become a danger to my city, it's not going to go well for you. You just had a case dismissed not a month and a half ago, and now you're here again. Don't be a danger to my city. Do you understand? Yes or no?
Yes, sir.
Because you have a lawyer, we will waive your appearance, but you must stay in touch with him, and he will tell you if and when you have to come back to court. Don't pick up any new cases. Does he have a, you said he was driving, right?
Yes, Your Honor.
Can you run him? Does he have a license?
Yes, I'll run it right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. That is also a condition of your bond. If I find that you're driving without either, likewise, I will arrest you, put you in jail. You understand, sir?
Yes, sir.
Judge's license is eligible.
Wonderful. So we'll have you go sign a reset now. We're going to have bond conditions created for you to sign. Once you sign it, after that, you'll be free to go. So we'll just have you wait in the jury box.
A new defendant is charged with DWI and unlawful carrying of a weapon after speeding 50 miles per hour in a 30 zone and failing to signal. During the stop, officers found a loaded handgun on the floorboard and noticed signs of intoxication, including glossy eyes and slurred speech. The defendant admitted to drinking 3 alcoholic beverages and later blew a 0.136 and 0.141. The judge finds probable cause and orders strict conditions: no alcohol, no illegal drugs, and no driving unless the vehicle has an ignition interlock system. The judge warns that every officer in Texas will be notified and that any violation will result in immediate jail time.